James, thank you as always for having us. We really appreciate it. Welcome to RELFest, and of course, welcome to the ILTA Litigation Special Interest Group. We're going to be continuing this tradition that we've done, as James mentioned. And last year we talked a lot about AI hallucinations, and we haven't left that behind. We're still going to do it this year. But if we look back on what we've seen the past couple of years, the commercial version of ChatGPT came out in November 2022. It made a big splash, shall we say, not only among people around the world, but also in the world of legal litigation, e-discovery, and legal data intelligence. We had the Mata v. Avianca decision starting in May of 2023, and we'll just call that one, as we Americans would say, the Marbury v. Madison of hallucination law. Those cases have expanded. As of approximately 27 minutes ago, Damien Charlaton's database of worldwide AI hallucinations decisions had reached 1,611. We thought it was a big deal earlier this year when it hit 1,000. So the cases are continuing. But we've got new issues coming about, and one of the most important ones is whether or not AI input, be they prompt, be whatever you work on in AI, is going to be protected by the attorney-client privilege or the protections of the work product doctrine. And for this fun-filled discussion, we're not going to just talk all AI all the time. There'll be some disclosure, e-discovery questions as well. But we have the I-team here, and it is always a treat to be here with my friends and colleagues, Jonathan Armstrong on the end here. Jonathan is here, of course, and we've got Fiona Campbell, as well as Linda Sheehan joining us from South Africa. All right, so to kick things off, Mr. Armstrong, why don't we start with you? What are you seeing as the big events right now? And by the way, we're going to keep this conversational. Although we talk about going from the world of the United Kingdom, Ireland, the United States, and South Africa, we're going to have a back and forth and discussion. And of course, as always, we ask you to join in the conversation. If you'd like to ask a question, let us know, because we'd like to record what you're saying, and I'll make sure to get you involved. And with that, on to Jonathan.
Yeah, thanks very much, David, and welcome again to these shores. We need your dollars. I think from my perspective, I mean, hallucinations are clearly really big news, and probably the majority of what I'm sort of seeing and talking about is hallucinations, and I'm consciously looking at this side of the room and law firms who've made mistakes, or junior lawyers at law firms who've made mistakes. But I think if I defer the hallucinations discussion for a short time, I think sometimes we lose sight of the fact that there is other stuff going on and other stuff in the e-discovery and investigations world that's problematical. So if I can, I'll start with the ITA Airways case. I don't know whether has anybody followed this, which is an Italian case. So it's sort of almost good old-fashioned e-discovery investigations problems raised from the start, but with a bit of a compliance spin. So it's a fine from the Italian data protection regulator, the Garante, of 190,000 euros, plus an order to destroy evidence or use it only in a restricted way. And it arises from a board dispute where basically it's an airline, used to be known as Alitalia. So the chairman of the board is involved in this whole boardroom squabble, if you like. And as part of his strategy, there's a whistleblower complaint which the airlines say that they're going to investigate. And they use a Big Four accountancy firm to assist with the investigation, and they use, thankfully, Nuix to to host the data. And the individual concerned, the chairman of the business, objects because he thinks that the investigation hasn't been conducted in GDPR-friendly terms, and he thinks that too much of his data has been sweated. And what's effectively happened, which I think is like pretty common for most investigations in my world, is they've looked at the data subject's email address, the chairman's email address, which SharePoint, which OneDrives are associated with him. They've created a forensic image. They've then put that into the software to interrogate the stuff that they've got. They've used a 21-month date range, which apparently is more or less the date range of the whistleblower. And then once they've imported that from the Microsoft environment, they've run 3 keyword searches against that whole pot of data. And then the accountancy firm have produced a final report, which I'm assuming, though it doesn't say in the regulatory finding, is somewhat critical of the chairman. So he goes to the data protection regulator and he says, all of this was unjust. This investigation was conducted unlawfully and the company should have known that. And the regulator starts to get in the weeds of what went on with this whole document collection review exercise, and says, first of all, to ITER, let's see the terms of reference with the providers that you used, and let's see the engagement that you had. And problem number 1 is ITER say, well, it was all under a written agreement. It's all done properly to comply with GDPR. And the guarantor, the regulator, says, I understand that. I just want to see the copy, the signed copy. And they then find out that they can't find the signed copy. I think with most regulators, you know you're on a sort of losing wicket if the first question you haven't answered persuasively. They then say, tell us where you informed the individual concerned about this investigation going on. And they say, well, there was an internal privacy notice, there was an IT usage policy. The chairman knew of all this stuff, partly because it was presented to the board, and he obviously knew it because he attached these things to his complaint to the regulator. And the regulator says, yeah, but that talks about employees. The board aren't employees, technically. He's the chairman of the board. He's entitled to think that the policy applies to employees and not to him. So they've sort of lost that bit of the battle. They then say, well, hang on, we did a big data grab, okay, but we cured that by keyword searching. That was fairly precise. And the regulator says, well, that doesn't cure it. You've already processed that large amount of data. And David, sorry to pick on Americans, but I maybe told this story before, but my grandfather in the Second World War maintained small arms on the northeast coast, and they've got no food, they're away from home, you know, they're 18, 19-year-olds manning these military bases. And but they had loads of hand grenades that apparently were past their sell-by date. So their answer to getting food was they would throw the hand grenades in the sea, bomb fish, and scoop them up in a net, the dead fish, and that would be a tasty supper. And why is this familiar to Americans? Because that's
I was just about to ask you, Jonathan.
Yeah, that's effectively the American way of doing internal investigations, whereas whereas the more European privacy-friendly way is to, you know, bait your hook and catch the fish you're actually going for. So ITER didn't, unfortunately, use my fish and hand grenades analogy, but effectively said the same. If you're going to conduct any investigation, and I think it's going to match e-discovery as well, you're going to have to be proportionate, and you're going to have to look at data minimization, purpose limitation, etc., etc. And the keyword searching isn't going to cure that. So I think it's a fairly spectacular loss for ITER. As well as the fine, they're also told that they can't process the data again, except in really restricted circumstances. And that's really bad news for them, because there's also litigation, and they were trying to use the same data pot to deal with the litigation as well. So it could end up, I think, costing them considerably more. And I think there are wider lessons for for our community as well, in terms of if we're supporting investigations, if we're supporting e-discovery. My sense is that a lot of firms go to the how rather than the why. And I think it makes us pause a bit to look at why we're doing it, what data set matches that, that purpose, and how are we going to balance the rights of others. So I don't know how many people are doing data protection impact assessments, for example, AI impact assessments, if they're going to use AI to sweat the data. I still think not that many people. I still think, from the cases I've been involved with, if I was stabbing a guess, 20%-ish. And I think that cases like it are going to be pretty much a disaster, because I don't suspect anybody in Italy is going to instruct the same vendors again for an investigation of this sort of magnitude. And obviously, the ultimate shareholder at the time was the Italian government, which I think also causes problems as well if you're trying to survive in that country with such a serious finding against you. So yeah, my first case is not hallucination.
Not hallucinations. Well, we may go with that theme. We may go back to AI and flip forth. But in defense of the Massachusetts fishermen of Cape Cod, American investigations, but not necessarily cage matches on the south lawn of the White House, why don't we take a trip over to South Africa? Linda, what's new in South Africa?
I'm going to take us back to hallucinations.
That works.
Because we don't,
that works.
We don't have any fishing cases, but we definitely lean on the UK and EU GDPR, as our privacy is written pretty much word for word with some nuances. So you're grenading on your own, I'm afraid. But I did think, because I don't have any exciting cases like Jonathan, I would do a whistle stop of what's happened in South Africa around the hallucinations, because we actually only have 5 cases on Damien's tracker, so it's quite quick. So we started in June 2023, which I think David and I...
We did.
We checked. The South African incident might have been the first one, but it was certainly one of the first 2 that ended up in a court decision. We were quite lightweight on that case, but the second case we endorsed INDA, which is the UK matter, so we've been quite zero tolerance on our hallucination in court cases. There's 2 recent ones this year, and it's swayed from being lawyers to one is litigant in person, and then there's another that is a potential investigation. So there's very little out there that I can speak to, but now we're looking at a potential High Court judge who's being investigated for the use of AI poorly in judgment writing. So that's what's on Damien's tracker. And if you're, not familiar with Damien's tracker, it's where the 1611 cases so far have been listed. But what we do have, in addition to that, unfortunately, is a more government-level hallucination, which has caused some issues. So we have a national AI framework which sets out how we want to regulate AI. And the initial draft policy was released for public comment a few weeks ago and was quickly withdrawn because it actually contained fabricated sources within the policy looking to regulate the responsible use of AI. So very quickly, it's very hot news, but there's been a lot of action taken because it goes to the credibility of, the government department that was selected to draft the policy. It goes to the individuals who are working on it, 2 of which have now been suspended, pending investigations. And there is now an external 7-member expert committee who is going to go through that policy bit by bit with a target date of re-releasing to the public in January next year. So looking at the failings, they're very similar to the lawyers who are relying on pleadings where they haven't verified properly. There's a similar pattern of not just putting your hand up and saying, yes, I didn't verify. There's discussions about a Chilean document that was translated from Spanish to English that is where the references somehow in some convoluted conversation that doesn't make any sense. So it's pending understanding the facts better. But ultimately, they failed on the normal verification. There was no source links to, there was a few publications that they referenced which just didn't exist or were incorrectly referenced. And there was no disclosure of the use of AI in drafting. So they say that they use ChatGPT for editing the document. But the consequences are now quite, far-ranging for South Africa. It means that our policy has been well, we're not going to see it until January, but for me, that's a really great thing because we had about 6 weeks to respond. We're actually going to need to respond this week. I wouldn't have been able to. So it's actually a great first release. We have a good understanding of what they're seeking to achieve. And just broadly, because I think it's quite interesting the take that South Africa has taken for the AI policy, the national. We've put ourselves forward as being looking to invest in innovation, and one of the key frameworks was around human talent and building infrastructure, but the policy itself was very heavy on regulation, and it was also looking at how to deal with harm after the effect. And one interesting point that they've brought up is an AI super insurance fund. Which is basically to say if there is no clear responsible party, person, entity, AI, for the liability of harm caused by AI, we have a fund that will actually compensate individuals. So I think it's great that it's actually been delayed to give us a chance to look at it. I think some of the critics are saying it's going too far on regulation and that we have the right infrastructure to be more focused on innovations. So, yeah, it was a bad day in South Africa, but I think hopefully it is a good thing in the end.
Great, thanks, Linda. Before we go back to Europe and see what Fiona has cooking, let's go back to the land of indiscriminate cod, haddock, and swordfish fishermen, Los Estados Unidos. But there's an interesting one, and this is not a hallucination case, it's not a work product case, but it does involve AI. And this is actually a copyright case, and it comes down to the question of, can AI be the author of a copyrighted work? This case is Thaler v. Perlmutter. Cert was denied, certiorari review was denied by the U.S. Supreme Court, and it comes out of the D.C. Circuit. And a gentleman named Dr. Stephen Thaler is a computer scientist, and he filed a copyright application for the work A Recent Trip to Paradise. Must be wonderful. But he listed himself as the owner of the copyright, but as the author of the copyrighted work, he listed the creativity machine. And you know where this story is going. The creativity machine was Dr. Thaler's creation, and it was his argument that it was the proper author because this artificial intelligence platform did, in fact, author A Recent Trip to Paradise. The court said no. The U.S. copyright law is clear under the Copyright Act that there is a requirement for human authorship. Dr. Thaler made the argument that this would, he couldn't get around the fact that the Copyright Act does in fact say that there is a requirement for human authorship, but he questioned the law on its face in that it would be detrimental to creativity, it would be detrimental to progress. The court rejected this, and I'll quote from the court's decision: "The human authorship requirement does not prohibit copyrighted work that was made by or with the assistance of artificial intelligence. The rule requires only that the author of that work be a human being, the person who created, operated, or used artificial intelligence, and not the machine itself." Dr. Thaler may be trying to make a point here. Later in the litigation, he actually went back, as he did want to protect A Recent Trip to Paradise by trying to make himself the author. But nonetheless, at least for the moment, the robots have not taken over artistic works. There still must be a human being as the author. But Fiona Campbell,
yes.
How are the robots doing in Europe these days?
I was making a note, just the word human, based on what you said, because I think that feeds into another point. And this comes, the initial case was a US case, Bradley Hepner. in which you'll know this one.
Oh, yes.
So Mr. Heppner received a subpoena, and before he was brought before the courts and brought before, he was raided eventually, but before all of that happened, he put many of the legal documents into Anthropic's Claude. And he then created documents on the back of that. And he tried to claim in the US, obviously different to the privilege as it is over here, but he tried to claim attorney-client privilege. And the court, Judge Radoff, I believe, rejected that. Radoff, sorry, apologies for the pronunciation. Rejected it on the basis that there was no human involved, there was no advice requested, there was no lawyer involved, and that not only does privilege not necessarily attract, but in order for something to be privileged, it must be confidential. And the warning shots are, if any of us are putting anything into any open source AI model, we are, based on the terms, potentially losing the confidentiality and therefore losing the privilege. So that's where the kind of human point came in. And I will get to the case law, but I just wanted to capitalize on what Linda was saying about the framework and the legislative framework in South Africa. And before we do a canter of what's new in terms of AI on the legal front, in terms of case precedent, I would like to just run through what the setup is in terms of consultations and initiatives. So the first is the Civil Justice Council. And has everybody here heard about that? If not, I'm going to go through it anyway. So what the CJC, it's a board made up of members of the judiciary, lawmakers and so on. And what they do is they provide guidance as to whether rules should be amended. And what they're now considering is amendments to the CPR, so the Civil Procedural Rules in the UK. And that's to consider AI use. So the first comes in the form of expert witnesses. So expert witnesses, in terms of this consultation, what's laid out is that they can use AI, they just say how the AI was used. And it's all transparent and put before the court. Now, the second one is witness statements. And just to recap, under the law, a witness statement must be in a witness's own words. So if you're then using AI, it's not necessarily going to be in the witness's own words. So what the CJC has suggested is that parties then using AI to assist with the drafting or to maybe help with the language syntax has to tell the other side that they're using AI and also tell the court, because the witness statement is a document that will be submitted to the court, but obviously different rules apply. The second one is in relation to Law Tech UK, and I'm sure everybody here is aware already, but I will recap. So what the UK Jurisdictional Task Force was working on over the past few months was a statement, a liability statement about where AI could be liable in certain contexts. Now, they've given some examples, things like professional negligence, things like using AI in tortious liability, things like product limitation, and so on. So there is a whole list as to why the AI might potentially be liable and what then, and again, it's all private law, but what then the sanctions or available remedies might be to parties. Now, again, because this is all going through consultation, it's not necessarily the kind of final output. There was something produced a couple of weeks ago, but everything is still being discussed, and there's a lot of discourse before we're going to finally have the changes. So with that in mind, I will hop back to the privileged.
Fiona, while
Yes.
you're pulling up those cases, an interesting thing happened, and I did a phone a friend and called Jonathan on this one, and that is we're going to at some point talk about the UK tribunal's decision in Munir that
Yes.
is one of these privileged decisions, and Fiona has already mentioned Heppner, which out of the Second Circuit came out. There's also Morgan, another US decision. These US cases came down in February of this year. Munir was published sometime later. However, the decision was actually written in November 2025. And in the United States, it is very rare for decisions to be held that long. But apparently, here in merry old England, the United Kingdom, also part of Great Britain. It is not. And so the ponder is like, which is the case of first impression? I went with, the English decision, the UK decision, I should say, was written first. Let's take a vote of hands. What do you think is the case of first impression? The one that was actually written in November 2025, or the US ones that were actually published before the UK decision? Who thinks that the case of first impression was the UK tribunal decision written in November 2025? How about the other way around, the American cases of Hepner and Morgan? Well, I'm on an island of my own on this one. If anyone's listening to this recording, let the record show that Horrigan is the only one who thinks that the UK tribunal ought to get credit here. With that, Fiona, we'll pass on to what are the American cases of first impression.
Well, I was actually going to speak about Monero, but I will also speak about the American cases. Thank you for your dissenting opinion there. So I'll just give some background to what happened. There were two matters in the upper tribunal, Immigration and Asylum Chamber. And these were Hammett decisions. And a Hammett decision is a jurisdiction unique to the UK where legal professionals are brought before the courts in relation to the duties and standards owed by them to the profession. Now, what happened in these matters, it was two matters held together much in the same way as Ayinde concerned two matters held together. So these matters are Mr. Tahir Mohammed of TMF Immigration Lawyers, and the second matter was Mr. Zubair Rashid, and he was practicing with city law practice solicitors and advocates. And the grounds that he submitted to the tribunal were drafted by a junior caseworker and part-time trainee called Wahid Malik. So these do not concern hallucinations. These differ in that they concern confidential information being put into open source AI. And in this case, it was ChatGPT. So in the first case, as the upper tribunal refers to it, Mr. Mohammed initially denied using ChatGPT, but later accepted that a false authority that was put before the court may have arisen inadvertently from using Google AI mode or another AI-generated result. He then admitted to using ChatGPT because one of the cases he cited was a non-existent case called Horrigan and SSHD. So the issue was he included Home Office decision letters and other pieces of information and other correspondence that came from the Home Office, and he put it into ChatGPT. He was given some authorities which he submitted to the court, but he submitted them and skewed what the facts were. So he was attributing immigration matters to an unrelated equal pay case. And then several authorities were either non-existent or wrongly cited or overstated a position or supported a position that simply did not exist. So what the tribunal did was they investigated who drafted the documents and how the errors arose. And then the second case was not simply whether AI had been used. It focused on the fact that a junior caseworker had produced grounds containing false, wrongly cited or unsupported authorities, and the supervising solicitor had failed to check them properly before filing. Now, you might recall with Ayinde, Lady Justice Sharp, have I gotten this wrong?
Sharp.
I literally had a blank moment. One of the main points of the judgment was that AI is like using a junior lawyer. Everything must be corrected, validated before it's submitted to the court. So this was very much what came out. And I think Jonathan is going to talk about a recent matter involving a city law firm where that has also happened within the past few weeks. So in relation to this matter, what happened was that there were some sanctions. So the tribunal then reported the individuals to the SRA. They'd also self-reported. They accepted that they needed to tell the regulators and the clients that they used these open source AI models. And Mr. Rashid's matter, his conduct was also referred to the SRA. So where they were doing warning shots and referrals to the SRA and AINDE, they're going slightly heavier now. Now, the point that came out of it wasn't what happened in that they used AI. It was the commentary around confidentiality and privilege. So because the matter was put into an open source AI model, where the terms, as any user would say, you expect this to be published on the internet, it loses confidentiality, therefore there's a risk it loses privilege. And what happens when you lose privilege and waive privilege? Those documents are all available. So that was kind of the key learning of it. And I think what it has done is it's highlighted the risks. So whilst we all might use Gen AI at an enterprise levels, the same guardrails and warnings still might exist, and that you might need to anonymize if you're looking for points rather than copy and paste or throw in a whole load of client data. It's about being smart, because you don't know the exact terms that your entity is signed up with these models. So it's just being that element to safer. There's another Irish case which I can cover called Gearan and O'Doherty. The same findings in that the lay litigant in the matter used ChatGPT to assist with an appeal. The appeal was very evidently drafted, just M dashes everywhere, as well as the language syntaxes showing that
May we take a brief moment here? How many people use, love, and adore the M dash? We have Ashley, yes, and Dina as well. And okay,
Emily.
I think, can we at least agree on this one, and hopefully I won't be the only one on this one, that the M dash is a useful writing tool. It separates sentences, it separates paragraphs. It's useful, and just because the machines have picked it up does not mean that it should not be used. Jonathan, you and on?
Yeah, I agree. I think I score relatively high on is this written by AI in my natural style. I've always tried to have paragraphs with clear headings. I've always tried to have shortish sentences. I can remember when I was tiny violin time, when I was a junior lawyer. I'm waiting for the jokes, but yes, we did have typewriters. But you ready? Just yesterday. Yeah, thank you. Give her another cucumber water. I had some client who said, I don't really understand it. So I got my nephew at the time, who was 13, to read the client advice back to me and tell me what it meant. And I've obviously had my own children. I'm running out of 13-year-olds. And I realize in the world of David Sullivan, that's probably not something I should say in public. But I think if you have that as a mindset and try and write clearly that clients can really understand, you end up writing in simple language. And that's why I think AI also does the same thing, which is why some of us score high-ish on an AI generator. But can I just say one other thing on this case before
you do, please, Linda Sheehan, your take on spotting AI written language and your position on the M dash?
Well, I have to say I've turned things written by AI, I've taken the M dashes out and put commas because I can't. It has taught me how to do bolding in bullet points, because I never did that before. I would do bullet points, but it does a bold, little concise 2 words. It's brilliant. I love it. It's my natural writing, but I have taken on some of LLM's way of writing.
I probably do the bolding too much. I used to be in-house for the magazine publishers, and there was a presentation there by one of the editors who said, in fact, they have done studies, and bolding in the middle of a sentence will bring the reader's attention. They have shown it, sort of like music in a supermarket, getting people to buy more goods if the music is pleasant. But anyway, with that editorial on behalf of the M Dash and Clear Writing, back to you, Jonathan.
Yeah, I just want to say that the bit I find unhelpful in Munir is, and this isn't a criticism of you, because I know that's the term in the judgment, is calling this open source software. Right. And the sort of techie in me says that's just the wrong term. And we've now got the wrong term appearing in a judgment. The objection isn't that the software was open source. The objection was that it wasn't very good, because it was consumer grade software. And we can have really good open source software or we can have appalling open source software. And this wasn't open source software. It was, in one case, probably Google Gemini, which is not open source as far as I understand. James will correct me if I'm wrong. And in one case, ChatGPT, which isn't open source. So we've sort of conflated what almost consumer grade AI, which I think is what the judges are trying to say is a bad thing, but we've mixed the wrong term up. And I think that bit of the case is really unhelpful. And I think we're going to have to look at better terminology and be much more precise, because the objection isn't that it was open source. The objection is it was rubbish.
I was at a talk about a month ago, and we had the same discourse around the language. And what we agreed on in that talk was to use publicly available data. And that, I know you won't agree with that, but that was a consensus. But I agree with the term. I think open source it's not the correct terminology for what we're dealing with.
Yeah, I've just written a peer-reviewed article, which I wish I'd never done for. I forgot we're public. Which I'd never done for all sorts of reasons. But and you're welcome to read it. It's in the Transatlantic Law Journal. I never do peer-reviewed academic articles anymore. But we, with the editors there, tried to struggled what is the right term, and I think we ended up with free to air. And as a general rule, free to air is a feature of most of the hallucination cases and isn't reliable. But I don't think it's to do with whether it's open sourced, whether the information's available on the cloud or servers or anything like that. I
always hesitate to jump in here because my employer, Relativity, is our host, and we are in an educational session. We are not selling software. But having said that, a lot of the terminology we use is consumer software versus legal software.
Yeah.
And an overwhelming majority of the cases where you see hallucination problems, where you run into legal issues, are consumer software. And another issue that comes up is this taxing on the courts? At least in the United States, some of the judges are arguing because the general public now has the ability to use artificial intelligence and create flowery prose in litigation papers, it is creating a huge backlog and huge issues for already overburdened courts. Now, there are some judges who have responded to that by saying, you know, we get better filings, and it's not as if someday, especially, and I don't mean to make light of these actions, prisoner actions in the United States where you are trying to challenge a sentence or challenge a verdict. Sometimes they're handwritten, sometimes they're difficult to decipher, and some judges have argued, you know, AI has really helped these litigants and make their arguments. So it can go both ways, but consumer versus legal is another option on that.
Yeah.
Isn't it really just about the contractual terms? So appropriate contractual terms, not appropriate contractual.
But I think your point about, I know I banged on about this in Chicago, so I won't bang on about it again, but this whole access to justice debate is really interesting, isn't it? Because a lot of people who know nothing about the topic say AI creates access to justice. And there is no, I'm on a New York State Bar Association, we've written guidance for New York State lawyers on it and others. And there's no credible evidence at all that that's ever happened anywhere in the world. What happens is that judges get bogged down. If anyone's ever worked in subject access requests, for example, in the last year, you'll see that the average subject access request has gone from that long to that long. And it's argumentative, and they demand £250,000 when they don't get all the documents they think they've got. And it's just become a nonsense. If you talk to employment lawyers, grievances are now 12 pages long with appendices. And judges are suffering exactly the same. I happen to know a magistrate, a lay magistrate in the UK, and she's getting just ridiculous cases. You know, somebody who traps a police officer's arm in a door, winds up the window and drives off in a dual carriageway, dragging the policewoman behind him in his van. and wants the policewoman prosecuted because AI and mumbo jumbo's told him that under the Magna Carta she's invaded his home because he sleeps in the back of his van. And it's sort of ludicrous and it's sort of laughable, but that would have been a guilty plea in and out of court. And now it's set down for a trial, so that's going to take 3 days, wrap up a courtroom, for this guy to spout his AI-generated nonsense. And this isn't access to justice. And justice delayed can be justice denied. And the fact that we're wrapping our judges up with mumbo-jumbo from ChatGPT, I think is something we should be ashamed of. And the fact that David Lammy, I'm going to stop being political in a minute, and I'm not party political on this, but the fact that David Lammy thinks that AI legal assistants are part of the answer to reduce court backlogs, again, isn't supported by evidence. And
Well,
I think your alma mater, Trinity, I think, has just done a report, I think, yesterday, saying that that's all nonsense as well, that Gen AI judges don't work.
well, so there's a few things happening as well. So DSIT, Department of Science, Innovation and Technology, are working on actual access to justice. So this is to avoid the inequality of arms. Because if you look at it holistically, if we all step away and we see who are using these enterprise AI models to assist with legal AI, it's big city law firms, it's international law firms, it's US law firms. So when you have Joe Bloggs who needs access to case law, a lot of the time you need to pay for a judgment, for example. You're not going to get it all free. So DSIT is working on proper access to justice using AI to allow ordinary litigants, lay litigants, access to this material that they otherwise would not have. And I do think that's a good thing. It's not ChatGPT spouting about case law, it's giving them access to the underlying information that they need without generating what they need to do.
Well,
It's a research tool.
if it works, I mean, you and I were both in the meeting where DSIT unveiled their plan, and I won't disclose what went on in the room, but safe to say, I don't know, if the plan was written in crayon by a child, you wouldn't have been surprised. Maybe that's too blunt, but it wasn't a great plan. And equally, is somebody going to find an obscure DSIT resource somewhere hidden on the government website, or use ChatGPT that's on their phone? These tools, if they're obscure, aren't going to be used.
Well,
and I think
Well, if they're all readily available, ChatGPT can then be directed to only look at the DSIT resources and then
possibly
do the research that way. So there are ways around it.
We may have somewhat of a split in the United Kingdom, but going to South Africa for just a moment here.
I just wanted to add, so one of the cases where it's a litigant in person, it was very, using ChatGPT, etc. It's a really long judgment, but I'll try and paraphrase. There was a lot of incoherent legal reasoning. There was, the hallucinations, and the other side had brought a claim of vexatious litigant and was trying to get them struck off. And after a long, convoluted fact pattern, the judge found that because of the way that our legislation is structured, yes, it was vexatious within that one claim, but it didn't meet the requirement for vexatious litigation, plural. But that, for me, is kind of going to what you're talking about, because I think, hypothetically, the litigant in person was getting encouraged by the tool to keep going back with new, incoherently reasoned legal objections.
Can I really quickly pick up on that theme? And I think the other reason why it's a problem is litigants in person are being sucked in, and that is getting consequences for them as well. So I think my favourite illustration is Your Home Partners and Kellican and HUD. So for balance, I think we've now covered most of the United Kingdom, because this is a Scottish case. And this is a case that is only about £5,000 to start with, £5,000 of rent arrears. The landlord's agents are sort of pseudo lawyers. They say, we can handle the whole thing, we can collect the rent. If it needs to go to court, we'll go to court. So they use the wrong form and the wrong procedure. And the sheriff, the sort of equivalent of a judge in Scotland, says, look, all of this is a nonsense, and directs the sort of court staff to say this is a nonsense, it's the wrong. And they come back, ChatGPT assisted, and say, well, you're wrong, judge. It's we're doing it right, you're doing it wrong. So the judge holds a hearing, again, real impact on busy judges, and basically says to the two managing agents who are effectively litigants in person, what are you up to? And I think we're finding a lot of these cases now where litigants in person, if they're told that their AI is wrong by a judge, they tell the judge that he's wrong. It's this whole empowerment thing about AI. It's like, I don't know, candidates on The Apprentice. They know very little and are very confident in their own ability. So when somebody says you're wrong, they just go, you're wrong, with no evidence at all. And I think you can see the sort of frustration on behalf of the judge here. And he ends up effectively having like a Hamid hearing, effectively, for litigants in person. And one of the interesting things he said is that the requirement not to mislead the court is a professional requirement if you're a lawyer, but it also applies to litigants in person as well. And if you're a litigant in person and you're using ChatGPT, you're effectively underwriting the output of that search engine. And again, back to the access to justice point, I don't think most litigants in person know that. And I know in Australia there's been an effort to educate litigants in person and tell them of the potential downside. We're both on the Law Society AI group, and I've asked for that to be on the agenda for the next meeting, whenever that is, to reproduce something like that for litigants in person in England and Wales. But I think that's really, really necessary, because I think a lot of litigants, particularly those who are using the fee waiver scheme, so they're just purning up in court because they're on low income, they're exposing themselves to loads of consequences without realizing it. And personally, I think government resource will be better concentrated on that education piece rather than some unicorn hunt that DCIT are up to on making more resources available that won't be used.
Fiona, your take on it?
Defend the unicorns.
No, I agree. I think there needs to be more structure, and I do think it's a situation of blind leading the blind at the moment. However, I think the idea behind it is a good one. I was going to make a separate point, because this is something which has been considered in the US, and I think it's something that we all need to be aware of, and it's the elephant in the room. It's in relation to disclosure and ChatGPT prompts, or any kind of open source AI prompts. Now, this isn't something which I have seen yet in disclosure, but it was considered in a US case, which is Warner v. Gilbarco. And I'll just give a recap of that matter, or a summary to those who have not been aware of it yet. But what happened was that the defendant sought discovery of the plaintiff's use of third-party AI tools and what the prompts were. And the court actually refused, holding the material was not shown to be relevant or proportional. And the court also said there was no evidence that the plaintiff had violated any kind of protective order, which was the matter, it was an employment case, by uploading confidential documents into the AI tools. But my point is that this brings further consideration, because as we all know, if we're dealing with disclosure, this extends to third parties or anyone who has something in their control, power or possession. And the same will go to AI prompts. And we're at a crossroads in terms of where the legislative setup is, whereby the courts, it looks like, will start seeking disclosure of prompts. So not necessarily within the confines of your, let's say, relativity error tool, this will go broader. So my guess is, and if I were someone who was in this kind of realm myself, I would set up my tools at enterprise level to delete after 24 hours for everybody, because otherwise you have a whole load of data. You not only have the prompts, you have the output, and it's something, I guess, it's coming in the UK. It hasn't yet happened. Thank the US for looking at it so far. But then it brings us on to a whole lot of other points, like professional negligence and where AI is liable, and you know, it's just a bit of a quagmire.
We've had one family law case, haven't we, where the prompts have been disclosable. G and K, it's called. It's a High Court case.
Didn't know that.
And it's basically on children being removed from the jurisdiction, and the judge had a look at the prompts of one of the parents. Yeah, I will do. Yeah.
Warner, that Fiona mentions here, is really important from a U.S. standpoint for two reasons. It's just, and I think that we all agree, it's a bizarre coincidence that Heppner, the first case Fiona mentioned, and Warner came out on the same day, February 10th. What's also important is they came to two different conclusions. There were a little bit difference in the fact pattern. You have to remember, Heppner was a criminal case, and most of the cases we discuss in the world of e-disclosure and e-discovery are civil matters. But secondly, the judge, and I suppose that Judge Patty in Warner was not trying to take shots across the bow at Judge Rakoff and Heppner, but nevertheless, one of the things that Judge Rakoff was saying in Heppner is, okay, you've put it into this public tool, and guess what? You've waived privilege, or you've waived the protections of the work product doctrine. You get into some nuances in that, at least in the U.S., to waive the work product doctrine, you've got to disclose it to an adverse third party. And that's not the case if you're just sitting there and you are the administrator of a Gen AI tool. But this quote from Warner, I think, is good because Judge Patty writes, additionally, the court agrees with plaintiffs that the pursuit of information is, quote, a distraction from the needs of the case, and the defendant's theory, which is supported by no case law other than a Law 360 article, once again, Heppner's on the same day, Heppner hadn't been published yet, posing theoretical questions, would nullify work product protection in nearly every modern drafting environment, as the result if you took that argument to its logical conclusion. Well, does that mean you put a argument into Google Docs? Are you disclosing it to Google? And these are really fundamental questions that the law is still working on.
Yeah. I think it needs to take a very practical approach. We're all using them.
Indeed.
You know?
All right. We are getting close on time. Would anyone like to pose a question to the I-team before we get into some closing thoughts? Yes.
Right.
Because we don't have a microphone, just somewhat of a rebuttal, and that is the point that education of litigants, in this case a domestic violence situation, where a domestic violence victim does not know what the law states, and Gen AI may be able to be quite helpful there.
Yeah, no, well, I'll stand corrected. Then I'd be really interested if you're able to sort of share. I can give you my email address. But I know that a couple of judges say that they have used AI for the same purposes. So I think you are actually right. I retract my words. That I think sometimes they have used it in family cases, I know, to take the judgment and then have an official court translation of the judgment to give to the kids in custody cases, for example. So you're probably right. That is a good use case, I think. But again, I'd say it's for all sorts of reasons. You don't want to be putting it into free to air. It has to be a closed system, and it has to be one that's going to be adequately supervised. And I suppose my real concern is about politicians using AI as an excuse to not fix the court backlogs. But I think you're definitely right that it has a role to play in access to justice in terms of simplifying what's complicated proceedings.
Yep.
Yeah. Yeah, that's a
I
really
agree,
good
though.
point.
I think it's really helpful, even just to explain in the most simplistic terms what things mean. I'm actually doing something for the courts at the moment where we're testing some open source AI against information that we already know to see what answer it's providing and just validating it that way. So I think even in terms of some of these other models, not necessarily the official court ones, it's just a situation of testing.
Great. All right, before we get into closing thoughts, thank you very much for everyone being here. And Relativity would like you to invite us. You probably saw it in your invitation to Jinbo Law afterwards. It's a very short walk or so. Please join us for, as they say in the UK, nibbles. That's not a term we often use in the US, but nibbles and cocktails, please join us for that. And before we get to the fun part, not that this is not fun, it's always fun being here. Closing thoughts. Let's first start off with Jonathan Armstrong.
Yeah, I mean, I think hallucinations are dominating, but I would rather that people also didn't lose sight of the basics. So it obviously highlights that. There's another case involving Jones Day recently where a lawyer, destroys evidence. I think where somehow AI is getting a lot of radio time, if you like, but I think we're missing some of the other basics of compliance, and we need to focus on those as well.
Thank you, Jonathan. On to Fiona Campbell.
I think everybody needs to be AI literate. If you're not, you will be left behind as a lawyer. Know your terms, know its capabilities. The next flux of work, I would say, in 2 to 3 years will be professional negligence that comes out of AI misuse. So be aware, document everything, have your guardrails in place.
Thank you, Fiona. And the final word with Linda Sheehan.
I will just echo from Fiona and compliance from Jonathan, but contracts. I know that you're not always the person negotiating the contracts, but every consideration in what you're doing with inputs and outputs with AI will come down to contracts. So I believe professional negligence and compliance, I think the first stop will be not being aware of where your data is going. We don't have time, but if you haven't read up on Anthropic's Fable 5, first time that we have a zero data retention is not available in enterprise. So, and rerouting of your data between models. So things are going to get more complex, which means we need to understand it better.
Thank you, Linda Sheehan. The only thing I will add is hopefully you can join ILTA at Nashville, Tennessee for ILTACon 2026. We're going to be talking about some of these same topics. It'll be the 25th anniversary of the tragedy of 9/11. So we're going to talk about how that relates to disaster recovery and data protection. And all these thoughts here will be continuing at Relativity Fest in Chicago on September 29th. Hope you can join us for that one as well. And with that, on behalf of the International Legal Technology Association, thanks for spending part of your day with us. See you tomorrow.